Welcome, everyone. Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance, the #1 corporate governance podcast for 2026, as determined by Million Podcasts. I'm your host, Jeff Mahoney, General Counsel of CII. Our topic for this episode is Reincorporations and Nevada corporate law. And my special guest today is Benjamin Edwards, Associate Dean for Faculty Development and Research and Professor of Law at the UNLV William S. Boyd School of Law. Professor Edwards is also Senior Counsel at Wilson Sonsini. Professor Edwards is here today in his academic capacity. Welcome to the program, Professor Edwards.
Thank you, Jeff. Glad to be here.
Professor, you perform a great service for investors and other market participants by tracking corporate reincorporations and posting updates on the Business Law Professor's blog. Can you highlight for our listeners some of the key trends from the data you have collected and analyzed to date related to the reincorporations in 2026 and how that data compares with the reincorporation data from last year?
Happy to. So to set the stage for this, I want to go back one more year to 2024. And Glass Lewis collected information for that year. And when it looked at reincorporations then, only 23% of reincorporations were leaving Delaware. So most reincorporation activity was flowing more toward Delaware. So in 2025, we saw a change. Roughly 2/3 of reincorporations were companies leaving Delaware and going to other states. And so far, in 2026, it's largely consistent. What we have now is roughly 70% of reincorporations are now leaving Delaware. And so we have some consistent trends and a few points I can make. First, relative to 2025, Texas's performance this year has been incredibly strong. So part of that is that Texas has done very well with companies that have a Texas headquarters. And so there's a story here that most of what you see with movement to Texas is companies centralizing their governance with their operations. And so instead of having to go and hire counsel in Delaware, they have sophisticated counsel already in Dallas or in Houston. And so by staying in Texas, they're able to keep using the same firms and the same lawyers for their governance work that they often would for securities or other operational work. And so that trend continues. Nevada is looking a little bit different. Unlike Texas, the companies Nevada is picking up are generally widely dispersed. So they have headquarters all over the country. And you also see different market segments coming toward Nevada. So one of these is companies that are probably looking for a break on the price. And so you have different market segments here. Delaware will charge up to $200,000 a year for smaller public companies in terms of an annual franchise tax. For larger or large corporate filers under Delaware law, those companies will pay about $250,000 a year. A lot of times when people look at this, they tend to think about it as a one-time expense, but it's a charge that happens every year. And so if you analyze these fees as a perpetuity or something akin to a perpetuity, and you think about what is the present discount value of that over time, it depends on what interest rate you pick. If you pick a 20% interest rate, it's about $1 million. If you pick a 3% interest rate, it's about $6 million. For companies that are picking Nevada, oftentimes for the subset of companies that are smaller market caps, smaller revenues, a lot of these companies, the franchise tax cost is really driving it. And so sometimes you'll see companies looking at ways to mitigate this. And one good example is a company that was operating under the name Gaxos.ai. And it proposed two different possible transactions. One was to reincorporate to Nevada to cut its fees. The other was to change how many shares it had authorized under its charter in Delaware. And the idea was that by bringing down the number of authorized shares, it would change its tax burden under Delaware law. That came with a downside that if it needed to raise more capital, it would have to change its charter again in order to authorize more shares to be able to sell them. And so ultimately, the proposal to move to Nevada passed, and it was able to make a move. The other subset you tend to see is often large founder-led firms, which are looking to come to Nevada for operational flexibility and to mitigate governance process costs. One good example of a founder-led company is Zigna. Mark Pincus operated a Delaware company, and he tells this story that when he wanted to buy a mobile game called Clash of Clans, he'd worked out a deal to buy it for $400 million. But his existing board was full of independent directors, which he wanted to have in order to make things easier under Delaware law. They didn't want him to pursue that. He had the ability to fire them, but decided not to because of the litigation risks and the other concerns about trying to do it under Delaware law. As he tells the story, 2 years later, the company he could have bought for $400 million was purchased for around roughly $11 billion, and his stockholders missed roughly 26x return because of the governance process costs. Now, that's his version of events. There may be other deals that would have lost money that were also blocked, and we don't know that. But when you're looking at why companies are moving or what's going on, a lot of times they're looking for more operational flexibility. One of the other interesting things that's going on in the market right now is that it's not just reincorporations where different jurisdictions will compete. It's also in the IPO market. And so usually you have to wait until the end of the year before we start seeing these statistics. But I worked with some research assistants to put together a big data set to look at what's been happening so far in 2026. Now, historically, Delaware would always get 80+% of the IPO market. Companies would either tend to incorporate in the place where they did business primarily, or they would pick Delaware. Delaware recently put out its report for last year, and that report said that Delaware had nearly 70% of the IPO market, which is a pretty significant downturn for Delaware. What I found for 2026 is that if you take into account SPACs, Delaware has about 26% of the IPO market so far. But if you look at just operating companies, which is probably the better measure, Delaware is at roughly 64%. That's with 88 operating company IPOs. I also took a closer look to see how maybe these operating companies might break down in different ways. And so for companies that self-identify as controlled companies and that we flagged as controlled companies, only 54% of them were going to Delaware, where non-controlled companies were picking Delaware for an IPO at about 74% of the time. And the lesson I took away from this is that it may be that today companies with controlling stockholders may just be a bit more wary about going to Delaware.
Professor, your analysis shows a tight race between Nevada and Texas as the most popular destination state for companies reincorporating in 2026. So give us your prediction about who's going to win that race by year end and why will they win?
So I really have two answers here. The first is it's a fun horse race kind of question. And then you have to figure out, well, how are you going to measure it? Is it just the raw number of reincorporations or is it the market cap overall? Today, Texas is going to win under either of those counts. If you just look at how many companies or total market cap. There's another way to look at it too, and maybe it's against expected performance. You would expect a company with a large economy, or excuse me, a state with a large economy to have more incorporations and more IPOs. And so Texas has probably underperformed historically relative to the size of its economy. And so Nevada here is drawing a lot of incorporations from companies that aren't headquartered in Nevada. And so that's, I think maybe Nevada has a real chance there. But if we're thinking about who's going to win this year, Texas is currently firmly in the lead, and there's no reason to expect that the last 5 months are going to be radically different than what we've seen so far. So I expect Texas to end up with the most companies overall so far this year, and probably the most companies in terms of just market cap. The other answer here that I think is really the real answer is largely that every state is winning to some degree. Delaware is winning here because it has avoided any kind of massive outflow. What we're seeing is some activity. The numbers are small, but they're steady. You're not seeing any mass migration in any real sense out of Delaware. Texas is developing steadily. Their success at winning reincorporations is part of a larger branding and operational play to make Texas the best state in the country for business. And Nevada is continuing to grow. And so for us, as a small state here in Nevada, you look back at 2025, Nevada picked up about 25 companies. And that's not very many. It's less than 1% of all the public companies that are in Delaware. But Nevada had about 250 public companies before that. So you're looking at roughly a 10% growth for Nevada's public company environment. So far in 2026, Nevada's got 14. And that's good, steady growth. It's good news for my law students who are probably going to end up practicing Nevada law. Long term, in terms of what I think is likely to happen, Texas may have a bit of a ceiling in terms of how many companies it will ultimately attract. If you are looking for companies with significant operational ties to Texas, and those are the ones that are moving, eventually, Texas is going to run out of companies that sort of fit that profile. Nevada, may continue to grow. You've got increasing market familiarity for Texas law and Nevada law, and Delaware is going to remain a steady presence. So long term, it may be that you have Nevada and Texas developing into more stable competitors over time, but I don't expect Delaware is going to go anywhere.
Professor, you're a leading expert in Nevada corporate law. So let me give you a hypothetical. So let's say you're a long-term institutional investor voting on a proposed reincorporation of a public company from Delaware to Nevada. So what do you believe to be the key differences between Delaware and Nevada corporate law that a long-term institutional investor should consider before casting their reincorporation vote?
When you're thinking about this as a long-term institutional investor, I'd want you to think about it differently depending on the size of the company. So if it is a small company, you should probably pay more attention to the cost avoided by avoiding the franchise tax. This is going to be absolutely material for smaller micro cap, nano cap public companies. If it's a mid-range company where maybe the franchise tax cost by itself isn't going to be the most material thing, you want to think about, is the franchise tax combined with litigation cost or other governance costs going to be a drag potentially for this company over time? And for large companies, you want to think about whether the litigation risk that they're facing is really going to be material over time. Is it going to be something that is distracting management? I would encourage you to think about whether the level of litigation activity and litigation in Delaware is really optimal for the companies in your portfolio or for this particular company. But if you're turning and thinking about Nevada law in particular, core difference is going to be that Nevada has a more statutory structure where a lot of answers are going to be given to you by the statute, so you don't have as much need for judicial precedent. However, there are still some real differences. And I think you want to think about Nevada's statutory business judgment rule. And the rule really has three parts. The first is a presumption that a board of directors is operating on an informed basis and in good faith. And then, if you're going to establish liability, you have to rebut the presumption and show two things. One, that the director or officer breached their fiduciary duties, and that the breach somehow involved intentional misconduct, fraud, or a knowing violation of law. This is the Nevada statutory default. And a lot of times you'll hear people say that this goes too far. But what often doesn't get said is that the exculpation that is available under Nevada's statute is very similar to what is available under the Model Business Corporation Act. And so there's some differences here where Nevada actually has more liability than the Model Act when people take advantage of it. And there's some areas where Nevada might have a little less. For example, the Model Act has a provision that says explicitly that a director will be liable for any improper benefit they received. Nevada doesn't tackle it quite the same way. It captures it under intentional misconduct. So you often hear people say things like Nevada, basically replaces fiduciary duties with anti-fraud liability. That's not fully accurate. So the key here is that in Nevada, you're not going to have liability or some unintentional breach of your duty of loyalty. So unintentional disloyalty in Nevada is going to be exculpated. And you could think about, well, what does that really mean? Oftentimes, you're probably looking at things like oversight liability, where there's been some mistake and the directors haven't done a good enough job. Now, if you're trying to figure out where the boundaries of that are, Nevada is not going to go as far as Delaware, but there's a recent case from the Nevada Supreme Court, it's Chur 2, if you want to look it up, where the Nevada Supreme Court indicated that if directors are violating insurance regulations, that might be a good way to plead that they engaged in knowing violation of law. And so the idea here is that you're going to be able to get liability under Nevada law in more circumstances than people might anticipate. And it is not true that Nevada is going to be only potentially for fraud. So Nevada is going to offer more flexibility for companies where there's a focus, on operating and not, just maneuvering to try to, over lawyer and manage litigation risks. But there's also been some real misunderstandings about Nevada law. So some of the published critiques that I've reviewed suffer from real overstatement issues and have contained serious sourcing problems, quotations from cases where the quotations don't actually exist, actual Nevada Supreme Court decisions get overlooked, and the papers rely on unpublished federal district court decisions that have been characterized as Nevada decisions. So this is part of the reason why I and Nevada's governor and other Nevada lawyers put out a formal response, to some of this earlier this year. The real concern here is that the misunderstanding is about the degree of liability possible under Nevada law, and it's a double-sided problem. It is true that Nevada is more protective than Delaware, but it is not true that you can get away with anything under Nevada law. And so I say this problem is double-sided because there's two risks here. One is that institutional investors may be hesitant to vote in favor of a move to Nevada if they think they're not going to have any rights, where they might be more comfortable with a move to Nevada if they understand it as a bit of a reduced liability regime. However, there's still accountability for serious misconduct. The other consequence that I'm worried about with these misunderstandings of Nevada law is the possibility that it might influence management behavior. And so if you think that you can get away with anything under Nevada law, you may be more inclined to take egregious risks or do things you shouldn't be doing under Nevada law. And if I'm advising a corporate board, I would want to stress to them that there is still a real possibility of liability under Nevada law. And one of the things I've run past a board in this sort of situation is a list of settlements where you've had substantial liability. Earlier this year, AeroGrow and Scott's Miracle Grow, there was a settlement arising out of that transaction for $16 million. Last year, LQR House paid a settlement of $13 million, which at the time was 60% of the company's market cap. The Workhorse Group paid a settlement of about $12.5 million. And last but certainly not least, Wynn Resorts, roughly $40+ million derivative settlement. And so that you have a significant number of these settlements and a range of them. Nevada's not going to have as many settlements, in part because it doesn't have as many companies. But there is still real liability available under Nevada law.
Professor, many investors and corporate directors and officers agree that one of the most compelling reasons to incorporate in Delaware is the recognition that the Delaware Court of Chancery is the preeminent forum in which to settle corporate disputes. So can you tell us what's the status of Nevada's business court and how long might it take for the Nevada Business Court to compete with the Delaware Court of Chancery?
Absolutely. So here, Nevada has struggled for some time with an observability challenge. And part of that is that so many Nevada decisions were never published to Lexis or Westlaw, and Nevada's filing systems can be a bit antiquated. And so there have been a significant number of Nevada decisions that haven't reached these databases that people tend to rely on to figure out, what law and practice are in different jurisdictions. So Nevada can be hard to observe from the outside if you're not a Nevada lawyer or you're not connected to the Nevada community. We've had a longstanding business court here that was set up as a docket system. And so you had a separate business court docket. Now, Nevada is doing two different things, and it's sort of a dual track to try to modernize our infrastructure for business law. So the first is an internal reorganization being led by the Nevada Supreme Court. They've created a commission to study these issues, and they've brought in a range of outside voices to look at how other states operate, what's happening. They've relied on experts from Delaware and Texas and academics from all across the country. And as an outgrowth of that, Nevada now has a pilot program in Clark County, where business court cases have been concentrated with two judges. And unlike what used to happen, these judges now exclusively serve the business court docket. And so they're not handling other cases. It used to be in Nevada that you might have a complex business law issue, but you'd have to maybe go into recess for your trial to handle some criminal law issue that another docket required. That's not a concern anymore. Now, the overwhelming majority of cases in Nevada are centralized before these two judges. We have business court in Clark County, which is where Las Vegas is and roughly 80% of the population, and a business court up in Washoe County, where Reno is. The vast majority of cases, though, are in Clark County. And so what we're hoping to see and what we're probably going to look at is whether centralizing and dedicating judges to this results in faster adjudication and more consistent application of law. We also have a separate process that I've been involved with, and it's a constitutional amendment to give Nevada the authority to create an appointed business court. And so this is, taking lessons learned from watching Delaware do some things really well. The constitutional amendment process in Nevada is slow. It passed the legislature in 2025. It needs to pass again in 2027. And then it will need to pass a public referendum to go into effect. And so In terms of when Nevada will be competing, with Delaware, here it's sort of, well, what do you need to be effective, at competing? On some things, the depth of judicial precedent probably, isn't the most necessary. On other things, the ability to have a case decided by a judge with real expertise, the ability to have a case decided efficiently, I think Nevada is becoming more and more competitive every day. Ultimately, in terms of dispute resolution infrastructure, I don't think any state is going to be able to match Delaware in the near term. But in terms of developing more case law, improving predictability, I think that's likely to continue, both for Nevada and Texas. And so it's just really just hard to say about when it will be fully competitive.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to thank my special guest, Benjamin Edwards, Associate Dean for Faculty Development and Research and Professor of Law at the UNLV William S. Boyd School of Law. Professor Edwards is also Senior Counsel to Wilson Sonsini. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, that's JEFF, at CII.org. Till next time, I'm Jeff Mahoney. Thanks again for listening to the Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.